Please. All right, the record will reflect that all parties are present on the same matter, following a brief recess taken. With regard to the intervenor Huff's motion for summary judgment, the court would deny the same. With regard to the plaintiff's motion for summary judgment, the court would deny the same. The court's put in an interesting position in this case of trying to unscramble an egg. That's impossible to do. The issue in this case, the source of the problem, is the floodplain ordinance. And when people's property rights are affected, that's a serious matter, and they have certain rights under the Constitution of the state of West Virginia with regard to those rights, particularly to be afforded with notice and an opportunity to be heard, so that they might have the ability to protect those rights. And the protection of those rights cannot be left to chance. And that's what we have here. We have a situation where the protection of the parties' rights has pretty much been left to chance, and the possibility or lack of possibility that they might find out what the county commission is doing under a particular ordinance and have the opportunity or miss the opportunity to protect those rights. The court believes those parties and those individuals are necessary parties in any proceedings that would affect those rights. As counsel are aware, in any matter, there are certain individuals who are necessary and indispensable parties to the action. And generally, under the rules of civil procedure, if those parties aren't present, then the matter cannot proceed. And if they are in a position to maybe even be aware of the action and not desire to proceed, then the action has no effect upon their rights inasmuch as they're not a party to the proceedings. I've carefully considered everything before the court. Believe me, I've got a stack probably equal to this or a little bit higher in my office. I've probably done more research and thought on this case than anything that I've ever looked at since taking the bench a couple of years ago. With regard to this case, the court would find that the Doddridge County floodplain ordinance at a minimum is in violation of the West Virginia Constitution to the extent that the ordinance fails to provide due process to surface and adjoining landowners potentially affected by the development for which EQT seeks a permit. And at the outside, to the extent that it fails to give notice to the public of any proceedings under the floodplain ordinance. To the extent that the ordinance addresses surface owners who desire to construct floodplain compliant structures within relevant FEMA requirements, the ordinance is constitutional inasmuch as it appropriately advances a legitimate public interest and is an appropriate exercise of governmental authority and power. The court's familiar with why these ordinances were put into effect and the basis for these ordinances. The court was familiar with them as a former prosecutor representing the county commission and has been involved in drafting and implementing these ordinances as well. And the purpose of these ordinances is to require that structures in a floodplain be built in such a manner as to not be damaged by any flood, which might require the application of taxpayer dollars for purposes of compensating the owners of those properties for damages, and to prevent that from happening. And to the extent that the ordinance addresses that, it is effective. However, the ordinance casts a broad shadow with regard to several other matters which it is deficient to address. The subject ordinance, when being applied under circumstances involving the request for a permit which potentially affects surface owners who are situate within or adjoining or affected by the subject floodplain, must afford notice and an opportunity to be heard upon the requested permit to this particular class of property owners. Without such notice and opportunity to be heard being afforded to this class of property owners, plaintiffs would not be entitled to the relief prayed for in the form of an injunction requiring the issuance of a permit for development within the floodplain pursuant to the subject ordinance. And again, this defect can't be cured by the potential happenstance discovery of what's been involved or what is being considered or the actions being considered. Unfortunately, in the absence of a clear right to the relief sought in this proceeding and proceedings requesting a mandatory injunction, the issuance of a mandatory injunction are considered to be the most harsh and extraordinary remedies recognized in law. And in the absence of a clear right to the relief sought, a mandatory injunction cannot be granted by this court. The plaintiff has no clear right to the permit, not through any fault of its own, but because of the ordinance. And compliance with an unconstitutional ordinance is insufficient to give that right if the ordinance is constitutionally defective. The court doesn't dispute that the plaintiff in this case has done what it was supposed to do under the ordinance. But if the ordinance is insufficient, it cannot establish a clear right to that relief. The court also finds that given violation of due process rights to class individual property owners affected by these proceedings and the circumstances of the parties, the balance of equities does not favor the plaintiff as the moving party. The court further finds that it would be totally inequitable to award a permit under the proceedings in their current form. Therefore, the plaintiff's request for injunctive relief is denied as a matter of law. There's no necessity to proceed with the taking of evidence on this matter, which factual arguments are regarded moot in the court's opinion under the current state and under the court's ruling. And since none of the proceedings before the appeal board in the form of the Daughters County Commission or in front of the floodplain administrator provide due process to constitutionally necessary parties to these proceedings, the court can take no further action in this regard. Additionally, it's my position that the court has no jurisdiction, as previously ruled, to hear any appeal, and has no jurisdiction to make a determination on the merits of whether a permit should issue, and certainly has no jurisdiction to issue a permit under the floodplain ordinance, and to require the administrator or the commission to issue a permit under the current floodplain ordinance, I think would be improvident and not wise by this court, or to reinstate a permit that had been previously issued would not be prudent or wise by this court, given the lack of constitutionality of the ordinance. I think the only way to proceed in this matter would be for the parties to proceed under some constitutionally proper ordinance for purposes of making a valid determination, giving the necessary parties notice and opportunity to be heard so that the matter could be properly considered. And in that regard, the court finds that the granting of mandatory injunction would not be well founded as a matter of law.
how do we get permission? I mean, we came to the county, we complied, there's no one that disputes we complied. There was never a question about our studies. There was never a challenge to our studies. There was never any issues with our studies prior to the time that was being issued, and it was issued. How do we then, as a party of interest, how do we then comply? Or how do we get it?
Mr. Pitt.
Well, Your Honor, first I'd like to say for the record, so it's clear, that the ordinance that the Dodgers County Commission enacted on September 21, 2011, was an ordinance that they did not draft. It's an ordinance that FEMA drafted and basically promulgated all over the state of West Virginia. And the reason the Dodgers County Commission, as I represented them, did not join some of the particular motions is, I do in fact believe that this ordinance is unconstitutional as a matter of law, at a minimum on the notice provision. And we have started a process to put together a constitutionally correct and valid ordinance. And I would suggest to Mr. Hendrickson that once that ordinance is enacted, that he will have a path to properly present evidence to the floodplain manager to consider for purposes of permitting this particular well site, and will be afforded the constitutional guarantees of due process under the new ordinance.
Thank you. Richardson?
We had talked about this very thing, how this turned out, the ordinance would be fixed. I know that she's probably not going to hear about me being involved, but I'm sure that one of Mr. Gilbert, he has very good framework already ready to
I have a motion about how good idea I think of Mr. Gilbert.
I understand.
Your Honor, just so it's also on the record, we have began a process of collecting information from various parties, even to this litigation, in an attempt to understand what issues others see, in an attempt to enact a constitutionally valid ordinance, and that needs to be done.
I mean, Your Honor, it still leaves one issue out, and that's our damages. I mean, we came, we complied, we did everything that was asked of us. We spent an awful lot of time and money and effort to get to this point, and we should be compensated. This isn't our fault. I don't, you know, whether the Dodgers County Commission voted or didn't like, they have the responsibility of making sure, as duly sworn officers and elected officers of this county, in this state, to make sure that anything they act is in compliance, not only with state law, but with federal constitutional law as well. And the fact that they do that, as the court has just properly ruled, should entitle us to our damages. Because we've done nothing other than comply with what they enact.
Mr. Henderson, I agree that this is through no fault of your own. And I guess, and Mr. Kevin's right, the ordinance that we passed in Pleasant County when I was a prosecutor was prescribed by FEMA. At the time it was done, everybody understood what was being done. Nobody had a problem with it, and everybody was viewing it in the limited context of some surface owner who wanted to build their house in the floodplain, a fishing cabin down along the creek, or whatever it happened to be. And that was the way it was applied. Unfortunately, the language of the ordinance is much, much broader with regard to the effect that it has, which is what has gotten us here today. And to the extent, I don't know if FEMA did not contemplate these types of circumstances, but I know that the federal government, comparable legislation, federal legislation, when it has to do with anything having to do with development in a floodplain, provides specifically for public notice and a hearing. So I don't think it was because the federal government wasn't aware of those issues. I think they probably looked at it in a limited context as well, of not paying people repeatedly for damages who continually want to build non-flood safe structures in a floodplain. And that is what it was intended to address.
Well, if I may,
Yes.
that's not exactly what I'm talking about here.
Oh, I understand.
Okay.
As far as your damages are concerned, you know, I don't know, this action hadn't been dismissed, and I think you have a claim for damages under the current pleadings, do you not?
Yes, Your Honor.
All right. So all I'm saying today is that as a matter of law, I don't think it's proper to grant an injunction, which is going to result in you being permitted under a statute, which is conceitedly, maybe not by you, at least by the county and in the court's opinion, unconstitutional. And I just think that it would be totally advised for me to do that. I just don't have the basis to do that. But to the extent that you want to pursue your complaint, I think you can develop it. And to the extent that you want to make a claim for damages, then that can proceed routinely as any other action would in this court or in any other.
Can I ask a second?
Sure.
Would like to go ahead and proceed, Your Honor, and put a witness on.
You want to bring the matter on for damages today?
I'd object to that, Your Honor. I think if that is going to proceed, that's the next step in this litigation. The county should be afforded an opportunity to brief that issue and perhaps bring on, I didn't prepare witnesses on the damage issue, didn't intend that to be part of the process today. And we certainly would like to have an opportunity to properly defend that claim.
Your Honor, we notice it for all issues, including damages.
Your best way to respond.
I would just add, my client doesn't have a stake in the payment of any potential damages, but for what it's worth, coming from the perspective of this intervener, I believe we would concur with Mr. Tennant that none of us were prepared to even witness anything like that, any kind of exchange today or any evidence introduced through witnesses pertaining to damages, so we would recommend that the court, or request that the court provide that opportunity to brief on the issue.
All right, thank you, Mr. Stevens.
Right or wrong, Your Honor, we decided today as an injunction. We expected it to be about the injunction all day. EQT seemed like that was what they wanted, and the damages were a side issue that may or may not come to be. But given just the vast amount of preparation you go into injunction issue, I'm not prepared to discuss anything, and I apologize for that. There's a lot of experts, a lot of documents, about the
All right, thank you, Mr. Richardson. Next.
We're seeking damages against the interveners. I guess we could then do that, but we're not doing that. So it's between us and the county commission. We're prepared to put a witness on top of that, how much we spent so far in this process. If Mr. Tennant at that point in time then wants to brief the issue, I guess we can brief it after the fact. Or we can enter into a stipulation as to how much damages we have and then brief the issue. I don't care. I'm not trying to take on a point, but we're here today to talk about all the issues, including damages.
Your Honor, I will represent to the court that in the process of the discovery to get to this day, under the irreparable harm issue, I've had an opportunity to cross-examine witnesses from EQT with respect to what costs they had in putting together their information for the permit and those types of things. But I think the whole issue has to revolve around the particular way that the court has resolved this matter today, which is finding that the ordinance was unconstitutional rather than finding any specific wrongdoing by the county commission in any particular aspect of what action they did or didn't take. So I think that's a wholly different issue, and that's why I'm requesting that I have an opportunity to brief the issue.
And again, I don't mind briefing it, Your Honor, but I think just what Mr. Tennant did was take your ruling and stretch it. All you said was he thought the ordinance was, as I understood the ruling now, I misunderstood you or misheard you, but you said you thought the ordinance was unconstitutional. You didn't say that anybody did or didn't do something wrong. And All we're saying is we think we're entitled to damages. We'd like to, either we can stipulate to the figures on, or we can put a witness on, and we're more than willing to brief the issue and submit the briefs to the court. Because they are what they are. I mean, we've given it to you to discover.
But we can give them the numbers.
Do you want to just work out a stipulation? That's the amount and brief it?
We can perhaps do that.
Well, I mean, I'd like to have on record if that's what we're going to do.
Well, let me ask a question. Do you intend, as EQT, to include in your damage request economic expense by EQT in the necessary work that was undertaken to seek the permit and the permits that were authorized?
Yes. Yeah.
I'm asking for all permits, DP permit and the floodplain permit.
Well, that's true. Yeah. Yeah. We would.
If they're useless, if you don't have.
Yeah. You can't drill it. You can't drill it.
All right, here's what I'm going to do. I'm going to permit you, Mr. Henderson, to submit to the county commission a list of what you claim your expenses are, with the understanding or the representation that you believe you're entitled to compensation for those damages.
All right.
I think whether you're entitled to compensation for those damages is probably a legal issue that the court would have to determine. So I think to say there are damages at this point might be a little premature. The funds that you expended for purposes of getting to this point. I think that would be a better way to proceed, not only given the nature of everybody's understanding as to these proceedings, but also given the nature of EQT's rights, and now that this court has denied them an injunction. EQT, by statute, can go to Charleston this afternoon, and the Supreme Court Justice in vacation present their arguments and get an injunction, in which case there may be no issue as to damages. The expenses would stay the same,
Correct.
but arguably you would not be damaged. So I don't think the matter at this point in time would be mature for this court to consider damages, and I think probably for this court to consider whether you would be entitled to damages, we'd have to know whether you have tried and failed to get an injunction from the Supreme Court, or do not elect to proceed in that fashion.
Fair enough. Would you be issuing a written order other than what you just read on the record?
You want a written order?
Yeah, sorry. Yeah. So we have something to take
All right.
if we decide to do that.
All right.
I don't think he has the power to do that. I don't know.
When do you want the order?
Your Honor, you're the judge.
Okay.
Okay, once I get it, I just don't want my appellate time to run until I get a copy of it. That's it.
Okay. All right. Well, it's my understanding that the decision of the court in denying the injunction is probably not appealable, but there's an alternative remedy independent of the appeal. I think all that the Supremes need to know is that you were denied by the circuit court. So in terms of, I can give you a quick order before you leave today and everybody can look at it and sign it, saying it was denied. Or if you want to wait a little bit longer, I can probably get you one with the findings and so forth that the court's done today. So I would endeavor to do that if I could the first part of the week, although I'm scheduled for court next week as well.
I think, Your Honor, and again, I'm not trying to burden the court. I understand your ruling. I think I'd rather have one that cites all your findings and conclusions. That way I have a complete order and so, because I'm afraid that if I take something else, then I say, whatever.
We want the whole story.
We agree with that, Your Honor.
Okay. All right. I'll endeavor to do that early next week.
So the procedure is, then I'm going to submit my claim for damages to the county commission.
Correct.
Okay. And then we're going to go from there and see what happens.
Right. And if you could CC the court file with that, so
Sure.
we know where you are.
Okay. Thank you.
All right.
Your Honor, again, at the risk of, I guess, lodging a complaint by at least presently innocent bystander, I would ask whether the court might be inclined to reopen discovery following that submission, so that the parties can inquire about the specifics underlying that claim for damages produce any documents relating to them, et cetera.
Well, I think Mr. Henderson said he doesn't desire to see damages against the interveners. Is that correct, Mr.
That's right, I don't think he has any standing to it himself.
So, with that representation, all right. Is there anything further at this time?
Nothing, Your Honor, thank you.
Thank you all very much. We'll be adjourned. Thank you.
Thank you.
I know everyone's disappointed they didn't get to testify.